this civil liability slide says, what does litigation look like? You know, I'm not gonna go into exactly what we experienced, but you know, as we're nearing issuing licenses and things like that, there were sort of last minute complaints filed in court, requests for judges to issue temporary restraining orders to prevent the council from issuing licenses. You know, these are things that I would reasonably foresee happening in a community where, you know, potentially that limits the number of licenses, and you have disappointed applicants that don't win the license, but don't think they're going to win the license, and suddenly you're on the eve of a council meeting, and your esteemed city attorney here is up late into the night responding to emergency motions and things like that. You know, so the litigation can be somewhat fast-paced, you know, and time-consuming. So I just wanted to make that point as well as I kind of wrap up the civil liability component.
Mr. Chair?
Council.
You may have addressed this already, but is there insurance that, you know, like, that we could get for being sued? Is there insurance out there for this?
You want to?
If your city is sued for monetary damage, then your insurance will usually cover your suit for monetary damage. But if you're sued for due process violation, declaratory relief of some sort, generally there's not insurance.
Okay, you said that about that.
So just as an example, if the sole allegation was for, you know, a declaration that the ordinance is invalid or something like that, you may find yourself without insurance coverage for the reason that there's no money damages being sought.
Through the chair. Mr. Attorney, you said you have some on appeal right now. The appeal is always granted?
Well, we don't know yet.
But my understanding, appeals aren't always granted, and a lot of times they're not. I mean, the percentage.
So you have appeals of right. So anytime there's a trial court ruling that disposes a case completely, which is what happened in our community, the cases were completely dismissed. So now you have an appeal of right up to the Court of Appeals. And then the Court of Appeals will hear and decide that case in time. And then the next appeal up to the Michigan Supreme Court would be by leave, which means that you have to ask permission to do it. But there's a high likelihood they take the case because it's an issue of first impression. There's never been a case like it before. So,
To the chair, if I can answer Councilman Johnson's question. From the trial court, or like the circuit court, to the Court of Appeals, there's always an appeal as right. You can always take that appeal. But the Court of Appeals doesn't have discretion to say we're not going to hear your appeal. When you're hearing about cases where appeals, the right of appeal has been denied, that's to the Supreme Court. The Supreme Court only takes cases that they want to take, and that usually because of some statewide issue that they want to address.
I think Mr. Johnson was talking about the ones that win, right? You know, what the percentage of winning in the Court of Appeal? Or
Right.
just take winning?
Yeah.
Yeah, but you're, I think you have a question. What do you think about that?
Marijuana
so
cases,
in a lot of cases, I don't think we know the answer to that yet because there's not been a ton of these cases. I mean, you look at like Traverse City, Westland, Berkeley. These cases are all going up sort of at the same time. So I don't think we've seen anything on that yet that I'm aware of.
But overall, with all cases, the percentage of winning in the appeal is lower or not?
I wouldn't necessarily say that. I don't know.
I would say that if you're the appellant, you want to take the appeal, well, let me say it a different way. Probably, it's more probable than not that the Court of Appeals will affirm the trial court. It's harder to get a case reversed in the Court of Appeals from what the trial court decided.
Council, question in reference. So the problem sounds like, let's say we set up for the number of locations, 222 for a while. Start low, and then we can always open more. So it sounds to me that most are the lawsuits coming out of who is picked to get the businesses? Is that where they're coming from? So the council has a right to say how many locations we're going to have in the city, right? So it seems like to me, the after fact of once the applications are filed, the lawsuits are coming in after denials.
I would say so.
So there's
agree that if you give everybody that wants a license, you probably won't get sued.
That's right. Thank you very much. No, I'm not going for that. But and that's what I'm saying. So, well, what it sounds like, we have to find a way as far as when it comes to being sued, doing it the right way the first time with picking who gets the license. And there sounds like, no matter how you may pick, you might get sued. Doesn't matter.
Yes.
So it's basically do or die, it don't matter.
Well, if you remain opted out, then I think there's a better than fair chance that you avoid litigation entirely.
Which in some cases is kind of fair. I mean, you look at it that way, but that's what gets me is you're always going to have those that didn't get it with an argument. No matter, anybody can sue if you get the right attorney, don't sue you anyway, right? So you're gonna end up with a lawsuit. So the situation still comes down to pretty much no matter what we do, you stand a chance of getting sued anyway. Thank you.
So, again, referencing back to Westland's ordinance, section 27-12 talks about application consideration policy. So that is not codified in the ordinances, correct? So where would we find that policy?
If you were to go on the City of Westland website, there is a marijuana page that has a lot of public information available. I believe the selection policy is in there. Also, if you were to look at the May 18th agenda packet, May 18th, 2020, that's the date that we adopted the policy, and it was included in the agenda packet for the City Council. And the fact that I know that date off the top of my head should tell you something about how much time I spent with it.
All right, because, yeah, I mean, that's one thing to consider when you look at the various boards. One thing that I had thought about when there were different televised meetings on the subject was almost a double blind selection process. I think right now in Westlands, it's a grading system, and then the top, person gets selected. But it doesn't speak to, like, say one got 95 points and one got 94. So one thought within the selection process, number one, to make certain that it is truly, can't be influenced, that if there are a number of qualified applicants, then through a random selection process of those qualified, if there's only one license available or two, that it'd be a blind draw. And then within the jurisdiction, that it'd be a blind draw. But then looking at, again, the application process, you have to have the site located, the address, to be pre-qualified. So I think anytime you have, I think in yours it was 3, in Taylor's, it talked about, different representatives on there. I don't know what those criteria are, so I'd like to look at it, but has that been, back to your point, has that been the issue, right? How they were graded, and did they sue to say that they should have gotten another 2 points on something that they would have been with Tom for?
So what I've seen in litigation around the state is that the commonly challenged criteria were criteria, frankly, of local importance. So things like economic development type criteria, things related to community benefits, Traverse City, Westland, Berkeley, all specifically, with mixed results at the trial court level. And the reason for that, just to back up a little bit, you mentioned a random, kind of blind draw type process. The MRTMA requires that if you're going to limit the number of licenses, that there be a selection process that's competitive. And so some folks have alleged that any sort of randomization in